Are you Shanna King?
Yes, ma'am.
And Mr. Wilkerson, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. King, in cause number 250295, you're charged with the second-degree felony offense of burglary of a habitation, and that's from December 13th of 2024. And how do you plead to that charge?
Guilty, ma'am.
Whoa, a guilty plea right out of the gate. No trial, no objections. Quick question for you, viewer. Would you ever plead guilty this fast, even if you did it? Let me know in the comments, because some people don't realize just how much they're giving up in these moments.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. King is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation, sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification.
Let's pause for a second. When the judge says she's now ineligible to possess a firearm, that's not just for a little while. That's potentially for life under Texas law. And if she violates that, it's a whole new felony charge. These consequences stack up fast.
That shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Wilkerson. All right, good luck to you, ma'am. You can go back with the bailiff.
Do I take this with me? Okay, thank y'all.
Good morning. Are you Johnny Jacobo Ramon?
Yes.
And Mr. Ramon, you were previously in court and entered a plea of guilty to the second-degree felony offense of accident involving death. And that was a plea agreement of a cap of 15 years in prison. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Defense has.
Yes, Judge.
Are there any additions or corrections?
No, Your Honor.
Not from the state.
Mr. Burbank, you may proceed.
Your Honor, this is a tragic accident. If you read the factual basis, which I know you did, a person was walking across the street at nighttime, and cars swerved, and my client actually hit him. As reflected by the charge, he failed to stop. He panicked, as in reference to his version, that is on page 1, and then was stopped up in Lumberton.
And now we switch gears from burglary to a fatal hit and run involving immigration issues and intoxication. Buckle up. This one's about to get legally messy and emotionally charged. Also, pay close attention to how each side spins the same facts.
He's been employed. He has family up in Woodville. He's been employed. He's got one problem. He is not a U.S. citizen. I would be arguing for probation in this case. but it is my understanding that there is a hold on him by immigration, and that he probably will not, if he got probation, he wouldn't be released. He has 2 prior DWIs from Tyler County that were taken care of. At the same time, what you receive, basically time served, 90 days jail. The intoxication charge that I believe were rejected by them, and probably because we're down here, they probably did it. Your Honor, I asked for there's a death involved, and I would love to have the minimum in reference to penitentiary time, but I'm asking for mid. I think that 15 is probably too harsh, and that's my opinion, especially in light of the facts and circumstances of this, in which the person was walking across the street at the time and being blocked by other vehicles, and other vehicles had to get out of the way. But he was definitely wrong in not stopping, and he was intoxicated. I would ask for anything less than the 15, because
If I could go back in time? Yeah, that's the kind of line that hits hard, especially when a life was lost. What do you think? Genuine remorse or damage control? These statements can impact sentencing, but only if the judge believes them.
I know where he's going to go, and that's a sad thing, but he's not here legally. And I don't know if he would like to address the court.
Sí.
Yes, sí.
Go ahead.
Quiero decir que lo siento, que si lo hubiese visto, yo me hubiese detenido antes para poder auxiliarlo, pero pues...
Hold on.
Judge, I'm so sorry. Had I seen him, I would have stopped and helped and rendered aid.
Pero pues había un carro con...
Hold on. Hold on. So are you telling me that you didn't know you hit someone?
¿Me está diciendo que usted no sabe que le pegó a alguien?
No, sí.
I did know.
Okay.
Pero pues había un carro enfrente y yo no lo pude ver
There was a
antes.
vehicle in front and I wasn't able to see him in time.
Okay.
Pero pues quiero decir que lo siento.
I want to say that I'm sorry.
Si pudiera volver el tiempo lo haría, pero pues,
But if I
sé
could
que
go back in time, I would go back and
soy el
help.
culpable.
And I know I'm guilty.
Okay. Thank you.
I just have one question up here. What were you doing for work?
¿Qué estaba haciendo de trabajo?
Estaba en el roof
I was a roofer.
And how long have you been in the country?
¿Cuánto tiempo has estado en los Estados Unidos?
14, 15 años.
14, 15 years.
And have you always had a job?
¿Siempre han tenido un empleo?
Sí.
Yes.
And you do have a family?
¿Y si tienen familia?
Sí.
Yes.
Thank you. Mr. Smith?
Judge,
This is the moment everything unravels. Not only did he lie about hitting someone, but he also tried to blame it on a deer. And that jail misconduct, yikes. That's not just bad behavior, it paints a picture of someone who may not be ready for leniency.
we would argue for the max sentence in this case on the plea agreement based on the fact that when he struck him, he knew that he struck him. That was evidenced by the phone calls. The next day, he knew he hit a person. When he was stopped in Koontz, which is a long way from the accident scene, he told the police when they noticed the damage on his vehicle that he had struck a deer. They, either through dealing with him before or suspecting that he was lying and knew he was intoxicated, went all the way back to the county line looking for a deer that had just been struck. And only because they were diligent in doing so did we even know that he had committed this particular crime. He knew he committed the crime. He lied about it. He has an issue with alcohol. He's here in the country illegally. I would direct your attention to the jail report in this case and how he's acting, showing disrespect for staff as well as masturbating in open bunk. We ask for a 15-year sentence in this case.
Mr. Jacobo Ramon, obviously the facts of the case are terrible. The fact that you didn't stop, the fact that you were intoxicated. And in addition, what no one, and I'm not even sure that when you were in our jail for some amount of time, there was a requirement that I release you because of the amount of time that had gone from the time of the offense while you were sitting in custody. I did that, and then you didn't show up. You are here illegally and have now killed someone. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And at this time find you guilty of accident involving death. Sentence you to 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It is in Spanish. I advise you to read that.
Got a case moving toward trial, but the defense hasn't even shown their client the video evidence yet. That's a risky move. Quick poll. Would you want your lawyer making decisions before you've seen the tape? Sound off below.
If you are ever back in Texas legally, you will not be able to possess a firearm or ammunition. That could lead to more charges against you. All right. Thank you. You can go back with the bailiff. Thank you, Mr. Burbank. Thank you, Ms. Burge. Good morning, sir. You're Corey Flemings.
Yes, ma'am.